In the biting cold of a Massachusetts winter, the body of Boston police officer John O'Keefe was found lifeless in the snow outside of 34 Fairview Road in Canton. His injuries were brutal: head trauma, abrasions, and evidence of a prolonged exposure to the elements. The woman who claimed to love him, Karen Reed, quickly became the center of a swirling storm of suspicion. Prosecutors painted a chilling narrative that she, in a drunken fury, struck him with her SUV and left him to die. The first trial ignited a firestorm. Reed's supporters protested outside the courthouse, waving signs and chanting. Inside, her defense raised pointed questions about missing data, biased investigators, and the blue wall of silence. The jury could not agree, and it was a mistrial. Now, as the second trial is underway, the stakes are even higher. The courtroom is once again a battleground as the search for the truth about what really happened that freezing January night continues. And today, more dramatic testimony and cross-examination of one of the most crucial investigators in the case, Trooper Buchanan. And we are live from the courthouse with all the big moments from inside the courtroom as the retrial of the century continues. I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. Great to have you aboard. And, you know, think back to that first trial. I mean, everything seemed to go right for the defense, and they were awfully close to an acquittal. You know, what we learned from the jury afterwards through the motion papers and everything else that was filed is that the jury had found Karen Reed not guilty on counts 1 and 3. And then on count 2, they were debating the lesser included. Like, that is the best case scenario for a defendant if the jury is going to get hung on something. It's the lesser included of the lesser charge. That's as close as you can come to an acquittal in this case. And that's where she was last time. And like I said, a lot of things were going her way in that first trial. Let's begin with the distorted evidence from that Sallyport video. Right there, this is what was shown to the jury, which is completely inaccurate. It takes the right side of the SUV and turns it into the left side, and turns the left side into the right side of the SUV. Completely distorting left from right in a case where the right taillight and the left taillight are really, really important. And prosecutors put that evidence, distorted evidence, in front of the jury. And it was the defense who had to expose that. Expose the fact that the prosecutor did it and the witness did not acknowledge that that video did not accurately depict what it was supposed to be showing. It was a big deal when it happened. And a big break that you can't plan for, but something that sort of fell into the lap of the defense. Then you had the suspicious searches, right? And Haslong to die became a big one. And then there was a battle of the experts, and the defense expert did well last year. The prosecution expert did okay. This year, they retooled that expert. So just like that Sallyport video, which will not be inverted in front of the jury in this retrial, the evidence, the expert evidence regarding the suspicious Google searches of Jennifer McCabe, the prosecution reached back in and got some more ammo to try to fight that allegation that Jennifer McCabe was searching how long to die in the cold at 2:27 in the morning. Now, they may or may not be successful, but they brought in more evidence to combat and to refute the defense's allegation and to fight the defense expert. So they brought in reinforcements. So an issue that they did pretty well in the first trial with, the prosecution had an opportunity to retool. Then there's the biased lead investigator, Michael Proctor, former trooper Michael Proctor. It was bad. We know it was bad. This was a witness and information about this witness that, again, fell into the laps of the defense just before the trial. All that information from his cell phone, all that incriminating information that ended up making him lose his job, what they uncovered on his personal phone was a result of the federal investigation Defendants normally don't get the personal phone data of investigators in a murder case. They just don't. I mean, they may try, but they don't get it. But the feds did get it, and then the feds gave it to both sides, and obviously the defense used it. That was a gift just before the beginning of the trial last year. And it seemed like Lally was defensive, the prosecutor last year, and they were kind of slip-sliding their way through trying to deal with their lead investigator being like, well, you saw what happened inside the courtroom. Well, now this year, you know, they have a year to figure out, all right, how do we deal with this? And it seems like what they're doing is trying to and attempting to really downplay the role of Trooper Proctor, or former Trooper Proctor, in this case. That he's really not that important. He wasn't that much of a big deal in all of this. So almost getting an acquittal, but ending up with a hung jury despite the controversy was a near win for the defense last year. It's going to be tougher this time around. A lot tougher. Because the prosecution has an opportunity to try to fix all those problems that seem to snowball against the prosecution and for the defense last time. All right, speaking of big witnesses, another big witness today. Let's go to Court TV crime and justice correspondent Matt Johnson, joining us live from outside the courthouse in Dedham tonight. Matt, great to see you. So today was one of those days where you have one and only one witness. What can you tell us?
Yeah, we haven't had too many days like that compared to the first trial last year, Vinny, but this was one of those days, day 12, and it was Yuri Buchanan. He was a supervisor of Trooper Michael Proctor, really minimizing Proctor's role in all of this. But aside from that, there was another big mood shift with this witness, and a big indication of how different trial 1 to trial 2 is. It's how they're presenting the evidence. First, they built a lot of different graphics, they're playing videos, but then they're also showing the evidence differently to the jury that's substantial, that you can hold. So that involved the clothing that Officer John O'Keefe was wearing. They were showing that to the jury today. They were showing his sweatshirt and also his t-shirt that were cut off his body, but they were showing it through plexiglass, and that's going to go back with this jury as they deliberate. That's a big difference from the evidence bags that we saw last year, but still it's a big moment, right? And he also showed the shoe and was talking about the missing shoe of the victim. Listen to this.
Did anything stand out in particular about his set of clothing?
In particular, we were missing a sneaker of his. That was very significant to me. It caused me to have Michael Proctor contact the paramedics that transported Mr. O'Keefe to the hospital and confirm with them, conduct a secondary check that that sneaker was not left behind in the ambulance.
Why was the missing sneaker significant to you at that point?
At that point, our theory had evolved to a vehicle strike based on the injuries, and I was suspecting that he was hit out of his shoes.
I mean, that's key testimony for this second jury, right? Because the first jury was a little bit confused in how John O'Keefe died. And this sets up testimony from what we're expecting a brand new witness this time around, a new crash reconstructionist from the Commonwealth. But I can tell you, Vinny, my years of reporting, whenever I've reported on a pedestrian vehicle accident, in most cases, there is a shoe left behind.
Yes. That's a big deal. You know, we talk a lot about the tail light, but the shoe at the scene, if the jury believes it, wasn't planted. I don't know if the defense is going to allege that it was planted, but that becomes a big problem for Karen Reed, because it's consistent with, right? There are times where it doesn't happen, but it is very consistent with pedestrian vehicle crashes that a shoe ends up off of the victim and all of that. So that is extremely important. It's also the way they presented the clothing. I really like that. And I like that because My concern is always the jury. I want the jury to get the best available look at the evidence. And I've never seen that done with the plexiglass before, but I think that's really effective. I don't know if they're going to ask to take it out, but you get to see the front, you see the back, and it gives you an idea of what it is, and it really plays large inside the courtroom as well, so powerful for the defendant. So let's get back to those shoes and those sneakers. I know different parts of the country, they refer to them differently. Boston is like New Jersey, where I grew up. They are sneakers that he was wearing. A lot of people are talking about John O'Keefe sneakers. What are they saying?
In my part of the country, California, we call them tennis shoes, but that's neither here nor there. But so yeah, you know, my big question on this is the jury confused about that bit of key evidence? Because when Sergeant Buchanan first showed it out of the evidence bag, he said that the shoe was recovered from 34 Fairview. There was a sidebar, which turned into a long break. Then he came back and he clarified and he said that this was the shoe collected over at the hospital. So that might cause some confusion. And then you have a lot of people questioning whether or not the shoes do match, because there are pictures in evidence of the shoe that was collected at 34 Fairview at the scene. There it is. Look at your screen. And by the way that picture is shot, it appears that the sole of the shoe is darker in color. It might be the lighting. It might be the snow packed onto it. And then there's another picture of two shoes side by side. The way that that picture is shot, one looks bigger than the other, one looks darker than the other, more dirty, I would say. So there's a lot of questions about all of this. The jury might have questions tonight. So I asked Karen Reed about it after court today. Take a listen. Karen, there's a debate over the shoes. Do they match from the picture to what John was wearing?
Just look at the evidence, look at the pictures. I didn't collect them. I've seen that, though.
Do you think did you see John go in the house?
I did.
You saw him go in the house?
I saw John go in the house.
Can you describe him going into the house? Which door and how and when?
No, I have, though, and I'm sure the prosecution will play it.
Okay, so that's an indication of what we're going to hear from the prosecution as we're in the middle or possibly the end towards their first part of their case in chief before the rebuttal. But now that's really key about this shoe. A lot of people, the media, we were all talking about that today. And then, of course, the Karen Reed supporters, there was a larger number here today in the buffer zone, and they were also talking about it.
Yeah, and it's a big discussion online, too. Everyone is posting pictures of the shoe in the snow next to the shoe in evidence and saying one has a black sole, one has a white sole. People have researched that Nike makes a shoe that looks like that with a black sole with the white around the side of the sole, but the bottom being black. So there's a lot of controversy about that, and we'll see how it manifests itself inside of the courtroom, how far the defense goes with it through cross-examination, etc. But I'm trying to figure out, okay, you know, is there a theory that a shoe was planted? Where did that shoe come from? Where's the other shoe with the white? How did someone have another Nike with a black sole? You know, there's a lot of questions that it raises. And another question is, why does it look dark, right? Okay. Trooper Michael Proctor.
Yeah,
will he testify? Will he testify?
Yeah, that is the million-dollar question, right? Especially when we're seeing so much different between trial one and this retrial. You know, we talked about it a little bit ago about the fact that Buchanan was really minimizing Proctor's role in all of this. There was also part of his testimony today where he was not calling him the lead investigator, and he was making a big point talking about chain of custody with key pieces of evidence and saying that they were not alone when those items were collected. Well, I asked Karen Reed, again, everyone else is under gag order, if she thinks that Proctor will testify. Here's what she told me. Karen, do you think they're going to call Trooper Proctor or not?
Nope.
Will the defense?
TBD.
So in the beginning, it says, funny, I am going through his client's phone.
Is that your comment?
No, it is not.
Okay, next.
It appears to be the same person because of the way that the extraction happens, and it says no nudes so far. Again, I believe it's the same person because all of these are identified as sent. It says, I hate that man. I truly hate him.
Do you have any belief that's Michael Proctor who was writing these?
Yes, I believe that is.
So you have Karen Reed, the defendant, the only one that can talk to the media right now. She tells me that at lunch. She told the rest of us, she doubled down, saying that she doesn't think Proctor will be called. She wouldn't let us know if she's going to call him. But so you have that. And then you also have Yuri Buchanan reading the text messages in open court of Proctor's, which Proctor read last year. They both testified, but Proctor read those last year. So I think we're getting a signal here that the Commonwealth will not call Trooper Proctor.
If they don't have to, I don't think they will either. But it does change the complexion of everything because it was such a big part of the first trial. Okay. Matt, get ready. I'm coming up next week. I need some good weather.
Looking forward to it.
Get me the good weather. Yeah. Matt Johnson in Dedham. All right, let's bring in our think tank. Joining us tonight, criminal defense attorney Eklund Mercy, also with us, retired criminal defense attorney Kirk Nurmi, and Nima Rahmani, former federal prosecutor and president of the West Coast Trial Lawyers. And they're not in a war with the East Coast trial lawyers. They all get along, so we don't have to worry about that, which is good. Okay, Eklund, I'm getting the feeling he's not testifying, at least for the prosecution.
Yeah, I think that anything he touches, for me, anything he touches, I believe is poisonous fruit. Like, I believe is fruit from the poisonous tree. I think that he has been compromised since the beginning. Anything that he's touched has been murky at best. Once you have a federal investigation based on the same case that you're actually testifying to, or that's actually the main point, it's an issue. If I was defense, I'm calling him up. I'm pulling his record. We're talking about every single violation in his file. We're gonna go through every single signature, every single step. I am running him through the ringer if I'm defense.
All right, Nima, as a former prosecutor, how do you explain this to the jury that your lead, if they do not call him, that you didn't call your lead investigator? What are you going to tell the 12 folks in the box?
It's hard, and that's why Eklund is one of the best. You absolutely want to put Michael Proctor on the stand if you're the defense. I mean, you want to put law enforcement on trial. This is defense lawyering 101. So if I'm the Commonwealth, actually, I call him, not because I want to call him, because he is a terrible witness.
Okay.
Or the racism.
But the question was, Nima, I know you would, but what would you say to the jury if you didn't? How would you explain that to them at the end of the case?
What I would say is this: listen, Michael Proctor, because the evidence came out today that he was fired. His supervising sergeant said that he managed him poorly, that what he said was offensive, that the investigation, he shouldn't have been on it because of his relationship with the people involved. What I would argue is this: even if Michael Proctor, you don't like him, even if he lied, even if he botched the investigation, that doesn't change the fact that Karen Reed hit John O'Keefe with her vehicle. That doesn't change the fact that she drank alcohol, that she said, I hit him, that she asked someone to do that Google search. So this is just a red herring because, Michael Proctor is a terrible person, but he's not on trial. He hasn't killed anyone. Karen Reed has, and I think that's the direction you got to go in. But it's a tough argument to make.
All right, Kirk, if the defense ends up being the ones calling Trooper Proctor, are there any landmines, any dangers for the defense in calling someone who is adverse to your case, someone who was the lead investigator, and someone who really, really hates your client and will blame your client for destroying his life and his career?
I would say in some circumstances there would be, but in this, there's not, because of all you said. You could attack him on the idea that, you remember Officer Buchanan, Trooper Buchanan said, oh, the investigation was professional. I would keep building up the things that are unprofessional about it. And he can't deny it. It's in black and white. It's in his text messages. We only heard a few of them today. I go in, as Eklund said, going to each and every text message. And if he shows animosity towards me or Miss Reed or what have you, I bring that out too. You blame her. You don't blame yourself. You were the head of this investigation. You did all this stuff. You still blame her. You have animosity towards her, just like you did when you were investigating the case. And that plays right into the defense's theory that this is a conspiracy that stinks from the top. And if Brennan doesn't call him, I say that he is trying to hide something from the jury as well, just like the state troopers were in this case. Ladies and gentlemen, you cannot endorse this with a guilty verdict. Walk my client out of the courtroom.
Nima and Eklund, do you get the sense that Kirk is getting ready to unretire at the end of this show tonight? All right, think tank staying with us. When we come back, we're going to take a look at John O'Keefe's clothes again as they were shown to this jury today. Powerful evidence, plus coming up next hour. Tonight on Vinnie Politan Investigates, we take an in-depth look at the now disgraced lead investigator, Trooper Michael Proctor. His conduct during the case cost him his job, but will it cost the prosecution an acquittal? Tonight, we investigate.
Join Court TV's Vinnie Politan with the
office in the state police section of the office.
So much for your career in caretaking. Interview with a Killer season finale, Sunday at 8 on Court TV.
Okay, so one of the big themes today up in Dedham, Massachusetts seems to be the downplaying of Trooper Michael Proctor. He really wasn't a big part of this case. He's only the lead investigator. Trying to follow me down, aren't you? Okay, so let's do this. Let's take a listen to the man who seems to be taking on more in this trial than he did in the first trial, which is Sergeant Yuri Buchanan, who was his supervisor. So he's going to seemingly testify to some of the things that Trooper Proctor testified to in the first trial. Take a listen.
We brought him to the temporary evidence processing area within the district attorney's office in the state police section of the office, where we have our desks and workspaces. There's a designated area at the time for evidence processing.
What did you do with the clothes once you got them into the secure area in the district attorney's office?
Once the clothing was in that secure area, we had to lay them out to dry.
What you did, if you could.
I had to lay them out to dry them. So I took a butcher paper, laid it out on the floor, and each item I removed and laid out onto that butcher paper to dry.
Was anybody with you helping you?
Yes.
And who's that?
Michael Proctor.
How long did it take for those items to dry?
Several days.
And were they in that secure area on the butcher paper for several days?
Yes, sir.
Are there times when that separate area was left alone, nobody watching?
Yes, sir.
Were those clothes ultimately moved from that area?
Ultimately, they were moved, yes.
The clothing items you took from the hospital, do you remember what items they were?
Yes, I do.
Can you share with us your memory of what items they are?
It was a two-tone gray sweatshirt, light material sweatshirt. It was an orange t-shirt. It was a pair of blue jeans, a belt, and a pair of underwear boxers.
All right, let's bring back in our think tank, Eklund Mercy, Kirk Nurmi, Nima Rahmani. Kirk, I love the way they're bringing the actual clothes in this time, and I think it's important. And I think it's important for this jury just to get to the truth, because they're going to have the photo of John O'Keefe's arm all scratched up, and now they're going to be able to have the sweatshirt as well. And I can see the jury trying to put things together here.
Yeah, but, you know, it really is still a puzzle, right? And these first several days of trial, the prosecution's really been focusing on refuting the Karen Reed's defense theory, and they're doing an okay job of it. But I don't know that these clothes, they're going to need some medical testimony. They're going to need cause of death that explains all this stuff. What explains the scratches on the arm as opposed to what's seen in the sweatshirt? You and Matt were talking about the shoe earlier. You know, how probable is it that a shoe loss? Trooper Buchanan talked about the headlight, the taillight. All these things are going to be combined together. They don't mean much in isolation, I don't think. And that's where really this case comes down to this manner and cause of death related to the SUV. Can the Commonwealth prove it and bolster it with some of these items as opposed to just this kind of random hodgepodge of items?
Yeah, and Nima, you know, putting this stuff and letting it go into that jury room so they can talk about it and they can put it together. Like, the experts won't agree. We know that. That's the way it works in the trial. So the jury will take that information and then eyeball this stuff themselves and use some of their own common sense to figure out, okay, what does this look like happened here? Does it sound more like what the prosecution expert said or the defense expert said?
That's absolutely right. And like you said, the prosecution has the advantage here because they know what the defense is going to argue. They're going to argue that he was beat up and O'Keefe was bit by a dog and thrown outside. So they have the advantage this time. Obviously, they're still dealing with their poor witness. They're still dealing with the botched investigation. But the fact that they can combat the defense theory of the case, because look, discovery, everything is one-sided in criminal cases. One of the really only advantages the defense has is the element of surprise, and they lost that advantage in this case. So obviously we have a new prosecutor, a new prosecution team, and I think they're taking a good approach in what is otherwise a tough case.
Yeah, but there was an awkward moment today. I'm going to walk through this, then Eklund, I want you to tell me what this all means. Let's start. You recall yesterday that Trooper Connor Keith testified that the left shoe was found at 34 Fairview. John O'Keefe's left shoe, left sneaker, his left Nike, on the curb beneath the snow. We saw photos of it in the snow, right? Left shoe. Today, Sergeant Yuri Buchanan pulls out the right shoe from the evidence bag. Take a listen.
Trooper, is that the sneaker that was at the hospital when you visited Mr. O'Keefe?
No, so this is the sneaker from 34 Fairview.
Okay. Could I have that marked? What is that, a left or a right sneaker, sir?
This is the left sneaker. Excuse me, this is the right sneaker from 34 Fairview Road, Kansas.
Yes, Your Honor. Sure. If you could put the speaker back in the bag and let Mr. Brennan bring the bag over, please.
What was that? I mean, he's saying that's the shoe that was found on the curb. No, that was yesterday in the left shoe. Take a listen now. They take this break, this mysterious break, and then they come back and it's like, oh, that never happened. Take a listen to this.
When we left, we were discussing Mr. O'Keefe's sneaker that you retrieved from the Good Samaritan Hospital.
Yes, sir.
Would that be his right sneaker?
It would be his right sneaker.
Do you have that sneaker with you today?
I do.
And again, could you open that bag and show that right sneaker to the jury?
Yes, sir.
Is that the sneaker you retrieved from the Good Samaritan Hospital?
It is.
I'd move that into evidence, please.
Okay, any objection, Mr. Jackson?
No, Your Honor.
All right, thank you.
What are we doing, magic tricks here? Eklund, what just happened? What is that?
Foolishness, because that's not the same sneaker. Listen, I am not a sneakerhead by any means, but that is two different sneakers. I think this would open the door to like a My Cousin Vinny type moment in which you make a sneakerhead an expert and you show very clearly how the sneaker in the snow is not the same sneaker in his hand. It's almost disrespectful.
Well, that's the one from the hospital, he's saying. He's saying that's the one from the hospital, although before everybody went to a sidebar, it was the one from 34 Fairview. What's going on here?
Lies are happening. Here's the thing. I think personally, I think Proctor was like a red herring. I think that whatever happened in that home, I think that it was on purpose that Proctor was on the investigation because of how trash he is. And I think it worked. I also think that whoever did it kind of overstepped their authority and thought that they had everything planned out. Here's the thing, we're not dealing with lay people. We're dealing with law enforcement. We're dealing with people who listen to motions, who testify emotions, who testify in trials. We're dealing with people who knows the little nuances for different cases. Oh, that person got off because of what? Because of a shoe. Or, oh, that person, whatever, what? Because of the light. Here's the thing, if somebody got hit and a tail light hit that person, the amount of puncture, the amount of goo and gunk that would be around on that car, it would be at least localized. And then we have a whole arm. I would need to see more. That's unreasonable. Then we have a jacket, right? So he was wearing a jacket.
Right, he was wearing a sweatshirt.
How do you have these things? Where's the tire tread? Where's the light pole? Where's is the arm broken?
All right, let's ask Nima, where is all this stuff?
Is it a broken arm? Is it a broken face? Do we have help me? Because I would like to see, how does it happen? When this hit happened, did he hit the hip? Did it hit the chest? It looks like the blood is on the front of a t-shirt. It's unreasonable. And how that evidence was able to come in, none of those, how did a car do that? That was because medical providers were trying to get to him. That is actually helpful to the defense and not to the plaintiff.
Nima, 10 seconds to respond.
That's why I went to law school, Vinny, Harvard Law School. That's for the doctors, Eklund. That's not for the lawyers. Let the Emmys come in. They're going to explain exactly what happened, why this medical causation was the cause.
Through the poisonous tree. We have Proctor. He's done everything wrong. Whatever you're supposed to do.
When we come back, folks, when we come back, how much was Karen Reed drinking that night?
At 10:53, how many drinks have been served to the defendant at this point?
7.
Objection, Your Honor.
I'm going to sustain the objection.
Interesting moment. Sergeant Buchanan on the witness stand talking about the video of Karen Reed at C.F. McCarthy's. That's the first bar that her and John went to. Then they went to the Waterfall where they met the other folks who went back to 34 Fairview. So I want you to take a look and listen to this testimony as he describes what's happening in these videos. And it's Karen Reed consuming alcohol, according to prosecutors.
What did that show, sir?
It showed the defendant receiving her first tall vase, cylindrical style cocktail glass with a lime in it and a straw to go along with it.
And what was depicted in that video that you saw?
In that video, we see the defendant get handed her second cylindrical tall style cocktail glass while she finished the first one and then picked up the second one. She's handed a shot by the bartender on the left side of the screen. She picks it up and puts it into her second cocktail glass, making it a third beverage of alcohol content that she's consuming. Now the defendant picks up her second cocktail glass with the added shot in it and consumes it. So the bartender hands over another cocktail glass and some beers. The shot goes into the empty one after it's poured into the new cocktail glass. So that's drink number 4. Here the defendant speaks with the bartender and gestures that she wants a shot.
Objection.
The objection sustained.
Move to strike.
The defendant retrieves the cocktail glass. A shot glass is picked up by one of the patrons, and the defendant retrieves it from him and places it back on the bar. The defendant is consuming the beverage in her hand, places it on the bar. The bartender makes 4 shots, top left corner. She's seen preparing the 4 shot glasses. 2 are on the bar top now. She retrieves 2 more, pours it into her drink. She does not consume it from the shot glass. Mr. O'Keefe and the defendant are getting ready to leave. The defendant is holding the drink in her left hand, continues to sip on it. And the 2 walk out of the bar without the beverage in their hand being deposited anywhere.
All right, Kirk, what's your takeaway from that presentation of that video of drink after drink, shot after shot?
Yeah, you know, it really illustrates, and along with the timeline they showed, it really illustrates the level of intoxication. And it's also kind of highlights, you know, what Karen Reed said in the various documentary. I forget what documentary it was, but she talked about the clips, about the drinks being weak and pouring shots in there and things of that nature. So, which was almost to me a confession to, you know, driving under the influence. And we just see a good illustration of that in these videos and in this testimony. It's going to make it awful hard for her to evade any conviction, at least as it relates to that count.
Nima, is this what this trial and this case should be about? Is drinking, driving, and allegations of drinking and driving and striking a pedestrian?
Absolutely, Vinny. I've been saying it since the first trial that this case has been overcharged. This is not a murder case. At least the Commonwealth does not have evidence to support the intent to commit murder or inflict serious bodily injury. This is, at best for the Commonwealth, a manslaughter case. They should be focused on her drinking, and they have. They've talked about the extent that she was drinking. Kirk talked about the documentary. We knew her blood alcohol content was a 0.09 in the morning. So obviously they extrapolated back. So I know there's a lot of Karen Reed fans out there. They're tweeting me all sorts of nasty things, but got to be fair. I think it's been overcharged by the prosecution. I don't believe in the conspiracy and the cover-up. There's no evidence that John O'Keefe was even in that home. On the Alpert's home on the night that this all happened. Had this been charged properly, maybe, just maybe, we would have had a resolution in this case in some sort of plea, but where would the fun be in that? That's why we get to do this a second time here on Court TV.
So, Eklund, Kirk mentioned one of the clips that was shown to this jury about the drinking. There were about 4 of them where Karen Reed is talking about the drinking. And the one Kirk mentioned, it seemed like she went to about acknowledging maybe 7, but there were some weak pours, so it didn't really count as one. Here she is early on in an interview with 2020. Take a listen.
When you walked out of the bar, how many drinks had you had?
I had probably about 4, and not 4 that I completed either. I didn't drink maybe more than a few sips at the waterfall.
And 4 drinks you felt fine to drive?
Yep.
All right, Eklund, how does the jury put this together? The clips of her speaking, talking about drinking, videos of her drinking, and the allegations in this case, and the top charge, which is murder.
Well, first of all, I would like to say I used to do DUI, so here's what I think. Number one, the first thing is the bar still open? Because according to the dram shop laws, you can't serve somebody if they're visibly intoxicated. So whatever video that they're showing, right, the bartender is legally obligated to stop serving you if you're visibly intoxicated. The evidence shows that, hey, She is standing straight. She's not wobbling. She's not moving. She doesn't need assistance. For her to be able to stand up straight and hold a glass shows that she is not under the influence of any alcohol to the point of detriment, to the point of murder. Yeah, I don't see that here. And I think that if I was the defense, maybe taking judicial notice on the dram shop laws and whether any charges were brought up against the establishment to show if she was drinking to the point of murder, because that's essentially what they're saying. And if you see everybody else, he hasn't stopped pouring drinks. So you're telling me that whole bar is under the influence to the point of murder? Yeah, I don't see it happening. I don't see it happening.
Kirk, what does the jury do with this? Her boyfriend is a Boston police officer, and he is the one, you know, he knows how much she's drinking, and he gets into the car with her.
Yeah, I mean, that's another argument. You know, you talk about the blood alcohol test that Nima referenced. You talk about Mr. O'Keefe and his consumption as well. And then you think about, well, did she drink afterwards? The arguments could be made that there was post-accident consumption, things of that nature, right? So, you know, that is a good, and Eklund made one, seemingly she's acting normal. Mr. O'Keefe gets in the car with her. She's not hysterical, what have you, until early in the morning when she is intoxicated and does blow that .09. That's the best argument I think the defense has to say she was not under the influence at the time of this accident, which of course the defense is disputing that it even happened. But that's the best argument.
Great job as always, Eklund Mercy, Kirk Nurmi, Nima Rahmani, thank you so much. When we come back, I'll reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, we go tonight. Take a look. New video. NBC's Dateline obtained video that appears to show the accused killer's car circling the King Road house before the murders of those 4 University of Idaho students. Dateline previewed their upcoming episode on the Today Show and included this new video.
We've obtained things that have never before been seen publicly, like these security videos from a camera on a house near the murder scene. Videos that show a white sedan, a car that investigators believe was driven by Brian Koberger, making repeated passes at the King Road house that night before the murders.
Prosecutors need all the evidence they can gather in that death penalty case coming up this summer. Take a look at your screens. We have a missing child who needs your help. This is Mackenzie Danielle Hayes, 17 years old, missing out of Lufkin, Texas. If you see Mackenzie, pick up the phone, 911, 1-800-THE-LOST, or the Angelina County Sheriff's Office in Texas. That number's on your screen. Let's get her to a safe place tonight. Don't go anywhere. We've got another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.
Thanks for hanging with me, Nikki B. Bye.